All right, I'm down here at Osgoode Hall, where Rocco Galati is representing patients for a Dr. Kustka in a legal challenge against the CPSO who want to access their patient files.
The patients object to the release of their personal medical information and their personal information because the investigation and demand for records is based on a third-party, non-patient complaint about a mask exemption written by the doctor for two child patients. The complaint about the girls was not made by a patient or even another doctor, but by a third-party interloper. The girls' parents and over 100 of the doctor's patients object to the release of their private, sensitive, and personal information on this flimsy basis as an unlawful search and seizure. Just to be clear so that you understand, the doctor was alleged to have given an improper mask exemption, which wasn't even required because the Ontario regulations gives everybody the statutory right to exempt themselves from masking. And because of that one isolated incident, the CPSO wants this doctor to empty out her entire patient filing cabinet and give over her entire medical records of all her patients.
Now, this case should be a concern to every single Canadian because it has to do with your private medical records, and that confidentiality will go beyond just the doctor-patient relationship. It may translate into every aspect of our lives.
No one's asked me for my consent to give my records to the CPSO, who is investigating my doctor for giving a mask exemption. I think it's horrific that it's happening in Canada. I think it's horrific for our children. I have children of my own, and I think about the fact that our privacies are eroding. A lot of people just aren't paying attention. And so really the purpose of our patient group coming together and forming a website, we're really trying to get the word out to people that you need to stand up for your privacy. You need to understand and become engaged in some of the things that are going on in the courts right now, because if we don't stand up, we are going to lose all our privacy and our medical records, and it's going to extend to much bigger things.
Now, Dr. Kustka has agreed to give the files, but in a compromised fashion where the names, phone numbers, and addresses of the patients are redacted.
Now, she had offered to redact the personal information so that their personal data and their personal identity would not be revealed, but the CPSO refused to take the records in that fashion. The CPSO claims that neither the public nor doctors' patients can legally challenge how it uses its powers. Essentially, it's saying the Constitution doesn't apply to us. This would make the CPSO unaccountable to anyone. The CPSO shockingly claims further that the patient should not have any say about their own medical records or how the CPSO wants to use that information, including their names and personal details that have nothing to do with the doctor's practice. It claims the doctor has to succumb to the unfettered power of the CPSO to all information about all her patients or otherwise risk losing her license.
And there in the background we see the legal team for the CPSO with their principal attorney, Ms. Block. They are arguing that the investigations for the CPSO trump the rights of an individual for the greater good, for the public, for them to have access to patient files so they can continue with investigations to see if a doctor's conduct and or practice is putting the public at risk.
I represent Dr. Kustka. The judicial review is about primarily the appointment of investigators under the health regulation professional code, what I call the code, under section 75, where the committee, the ICRC committee, decides if there's reasonable and probable grounds to believe that there has been misconduct or incompetence such that they can appoint investigators. And the Court of Appeal in a case called Cezanne has said that in order for a search and seizure power under Section 76 of the Code to be lawful and constitutional, there has to be a proper determination of reasonable and probable grounds under Section 75. So in other words, there has to be a proper appointment of investigators as a constitutional precondition for a proper search and seizure. If it was a search warrant, it would be like the court would issue a search warrant if the court found, based on evidence, there were reasonable and probable grounds to believe that an offense had taken place and that there was evidence of that offense to be found in a specific location. The Court of Appeal in this Cezanne case said, well, this committee determination of reasonable probable grounds is an adequate constitutional substitute for that warrant process because of the nature of doctor regulation. But what we've alleged here is that there is not adequate reasonable and probable grounds for several reasons. One is that the evidence just did not meet the standard of reasonable and probable grounds, which has to be non-speculative, and the evidence here is speculative. Two, that the alleged misconduct is based on violations of policy of various doctors' organizations and not a violation of a specific statutory or regulation definition of misconduct. And that's unconstitutional subdelegation and unconstitutional to be having someone found to be guilty of misconduct when it's not set out in law, but is set out in policy of private organizations. And the third problem is that Section 5.1 of the Medicine Act specifically says that you cannot be found guilty of professional misconduct or incompetence if you're using non-mainstream medical procedures unless there's evidence that there's an increased risk from using those procedures. It's a provision meant to allow for alternate medicine treatments as long as it does no harm in accordance with the Hippocratic Oath. And here there is no evidence that there was any increased risk for the alleged violations by Dr. Kustka. In addition to that, the Court of Appeal has said that there has to be a description of what the committee, the ICRC, found in terms of reasonable probable grounds, and that didn't happen here. And in fact, they were seeking material in excess of that, in, again, another constitutional violation. And finally, the application involves a constitutional challenge to Section 76 of the Code. It was already determined to be constitutionally valid in relation to one of the subsections, the inquiry process under Section 76 sub 1, where the College of Physicians and Surgeons can issue a summons and then ask questions of someone. That process was what the court was considering in Cezanne. But here, they're not relying on that. Here, they're relying on some combination of other statutory provisions under Section 76 sub 1.1 to subsection 4. And we've argued about the interpretation of that doesn't do what the college says it does. But in the alternative, if it does do that, then it's unconstitutional. And so these are the issues that are before the court to be determined, this interplay between Section 75 and Section 76 and other validity issues about Section 76. But basically what it's about is a challenge to the proposed seizure of evidence that implicates not only Dr. Kustka, but her patients. And that's why the patients are objecting to having their private records being obtained by the college. And the college says, well, we're not going to disseminate it to anyone. And the patients are saying, that's small comfort. We don't want the college to get it in the first place. And we say they don't have any right to get it. So that's essentially what we're arguing about.
And what the inclination of the court thus far is saying that a patient doesn't have the right to their own most intimate medical records about their treatment when it comes to the regulator. Well, this flies in the face of a clear and applicable and guiding jurisprudence or case law from the Supreme Court of Canada with respect to the rights under Section 7 and 8 of the Charter, which under Section 7 are the rights to bodily and psychological integrity as protected by life, liberty, and security of the person. That's already been determined by the Supreme Court. And Section 8 of the Charter, which protects against unreasonable search and seizure. So while the CPSO and even the Divisional Court says in this particular context, you have no protection to your medical records, and you have no say as to those medical records, what the court has done and what the CPSO is doing and advocating is that we ignore the fact that the Supreme Court of Canada has already determined you have a constitutional interest and right to your tax records, to your office media records, to your electricity bills. Your utility records are protected by Section 7 and 8 of the Charter in an investigation. To therapeutic records in a case going back to 1993 for rape victims, a case called O'Connor. And you even have a charter protection to your cell phone records.
So, Mr. Galati, after the adjournment, can you tell us what the decision was of the court in the case of PLAL versus the CPSO?
Well, after the recess, the court decided to quash the application of the patients, the application for judicial review, because the court says they have no standing. So what they're saying is that in law, the patients do not have an interest in their own medical file and information with their doctor when the CPSO, the college, comes around wanting the contents of the file. We don't have written reasons for this decision, so I don't know what their legal reasoning is, but we're going to be appealing at any rate. We're going to go to the Court of Appeal. We need permission, so we're going to be seeking leave of the Court of Appeal to appeal that decision. But I don't have the reasons yet. I expect them any day.
For any and all Canadians, whether they are following this story or not, and the mainstream media obviously has not reported on this, every single Canadian should be concerned. Can you say why?
Well, it means that your records with your doctor are not confidential. It means, like in these patients' case, a third party, just an interloper, busybody who has nothing to do with the doctor, has nothing to do with the patients, can just complain to the college, and then the college says, okay, to the doctor, you have to fork over all your patients' files. So there is no confidentiality in your medical records, and that confidentiality can be lost by some nutbar out there just complaining to the college.
Right, and that interloper was the Girl Guide Scout leader who was not happy with that two girls had mask exemptions, correct?
Even though they had every legal right to mask exemptions, that's right. So it's become a lawless environment where people make up their own laws. A Girl Guide leader decides she's bigger than the Ontario Cabinet, who says you can get exemptions, and triggers this whole invasion of privacy in the patient's records, because she's who? She's somebody who can make up her own rules. And the college, in order to abuse their authority, goes off and uses an excuse, and now we have a court that says you don't have an interest in your own medical files. You know, I've seen this before. When I did the Baker case on the that we won in the Supreme Court of Canada, of a woman from Jamaica was getting deported, notwithstanding that she had 4 children in Canada. We brought in a motion to have the children intervene and have a lawyer represent their interests before the court. And the Court of Appeal said that the children had no legal interest in the deportation of their mother from Canada. I mean, that's just insanity, right? To the court, we won on the basis of the best interest of the child in the Supreme Court of Canada, right? But yet the court is afraid of so-called floodgates. That if they have standing here, anytime the CPSO wants records from a doctor, that the patient can come in and argue about it. Well, yeah, they should. It's their right. But the courts don't want to deal with that extra work. That's what's going on.
Bright Light News will continue to follow this story and bring you updates when available. But we need your support in bringing you the news that other media outlets won't. Please donate today at brightlightnews.com or send an e-transfer to Gord at brightlightnews.com. Thanks for watching.